What happens when a federal judge defends gun rights more boldly than the same administration that claims to stand behind them? It sounds unbelievable, but that's exactly what just took place. A federal judge, yes, someone from the bench threw a major curveball at a gun restriction that's been considered untouchable for decades. For the longest time, the federal ban on machine guns was treated like a no-go zone, even by the most hardcore Second Amendment supporters. But now, a single ruling out of a Mississippi courtroom has shaken that assumption to the core. Millions of Americans remember Donald Trump promising to be the strongest defender of the Second Amendment we've ever had. Yet during his presidency, his Department of Justice pushed a legal argument suggesting that certain firearms fall outside the scope of Second Amendment protection. When that same argument resurfaced in United States versus Brown, Judge Carlton Reeves responded with a scathing 49-page decision that tore the government's position apart. In this video, we're going to explore what this ruling actually means, what it could mean for Trump's record on gun rights, and how the long-standing machine gun ban may not be as ironclad as Washington wants you to believe. For close to 40 years, the Hughes Amendment from the Firearm Owners Protection Act of 1986 has stood as an absolute barrier. No newly manufactured machine guns for civilian ownership, no transfers of any post-ban guns, and barely any public discussion allowed. But everything changed in 2022 when the Supreme Court dropped its landmark decision in New York State Rifle and Pistol Association versus Bruin. That ruling flipped the legal script, demanding that all gun laws be judged against the nation's historical tradition, and the shockwaves from that case just cracked the foundation beneath the machine gun ban. Now gun owners across the country are staring down a contradiction. On one hand, Trump still draws massive crowds wearing red ball caps, vowing to protect our rights like never before. On the other hand, the very legal argument his Justice Department used might now be unraveling thanks to an Obama-appointed judge who ruled that banning guns based solely on their rate of fire has no real grounding in American legal history. This moment forces gun owners to ask a hard question. Do we settle for campaign slogans, or demand that the Second Amendment hold up in actual courtrooms, with real legal precedent behind it? The phrase dangerous and unusual first entered the legal conversation in the early 1800s. But it wasn't until the Supreme Court's District of Columbia versus Heller decision that this phrase became the go-to justification for banning firearms that legislators consider scary. Judge Reeves agreed that belt-fed rifles are indeed dangerous, but he flatly rejected the idea that they're unusual. And that's where the government's argument starts to fall apart. Their logic was circular. The guns are rare because they've been banned for nearly 4 decades. And they're banned because they're rare. Reeves saw right through that flawed reasoning and called it out for what it is, an argument that goes nowhere and fails the constitutional smell test. Even folks who have zero interest in owning a full auto rifle can see the bigger implications. That same logic could be used to outlaw magazine capacities, stabilizing braces, or even specific calibers if the political winds shift far enough. If Judge Reeves's ruling holds up, the entire legal structure supporting those bans could begin to collapse, piece by piece. Here's the kicker. Justin Bryce Brown wasn't trying to make a political statement. He's just a regular guy from Mississippi. No criminal record, no extremist affiliations, no manifesto posted online. He bought an unregistered M16 lower receiver, and that one purchase landed him in federal court, facing a decade behind bars. Prosecutors based their whole case on Section 922, subsection O of the United States Code. Brown's defense team challenged the charge under the Bruin standard, arguing that the ban on machine guns has no basis in the historical traditions of the Second Amendment. And they claim that these firearms are more commonly owned than the government wants the public to believe. That's what makes this case so powerful. Brown is an average, law-abiding gun owner. For years, people opposed to civilian ownership of select fire weapons portrayed owners as either gangsters with Tommy guns or fringe militia types looking to wage war. Brown was neither. He's the kind of guy you might see at the gun range or bump into at the hardware store. That ordinary background made it impossible for prosecutors to paint him as a threat, and the media barely mentioned his name. But that silence says everything. This case wasn't about violence, it was about federal paperwork. At the heart of the matter was a single question. Can the federal government criminalize the possession of a part that modifies a firearm's rate of fire? The court said no, at least not in this situation. And if that interpretation spreads, thousands of law-abiding Americans who have faced jail time for owning certain parts could finally see those charges disappear. Judge Reeves started his opinion by admitting he was uneasy with how the Supreme Court's history and tradition test works. Still, he followed it to the letter. He began, as Bruin instructs, with the plain language of the Second Amendment. Do the arms mentioned in the Constitution include what Brown possessed? Even the government had to concede that machine guns are firearms and therefore protected arms. So, prosecutors shifted their argument to the old fallback, that these weapons are both dangerous and unusual. That's when Reeves dug into the historical record. The government pointed to a handful of examples. English laws banning armed intimidation. A North Carolina case from 1824 about concealed pistols. And, of course, the National Firearms Act of 1934. None of them held up. Reeves pointed out that none of those laws banned ownership entirely. They regulated use or public carry. They didn't justify an outright nationwide prohibition on a whole category of guns. Then came the statistics. The ruling referenced a figure from the Bureau of Alcohol, Tobacco, Firearms, and Explosives. 740,000 registered machine guns exist in private hands in the United States. The government didn't dispute that number, nor did they explain how many are transferable versus dealer only. They didn't even try to provide a lower total. Judge Reeves made his point clear. In a country where plenty of consumer products don't even sell that many units in a year, 750,000 cannot be labeled unusual. Sure, there are more semi-automatic handguns out there, but the judge emphasized that just because something is less common doesn't mean it falls outside the Second Amendment, especially not when the government played a direct role in limiting how many are available. He also looked at the crime data. Since the 1934 Firearms Act was passed, almost no murders have been committed using legally owned machine guns, and in at least 2 of those cases, the shooter was a police officer. That's hardly the public safety nightmare the ban was supposed to prevent. Reeves didn't ignore the danger. He acknowledged that machine guns are capable of tremendous firepower, but he reminded everyone that the Constitution protects dangerous things, free speech, journalism, and yes, guns capable of significant force. Being dangerous does not cancel out a constitutional right. And without the second prong being unusual, the government's entire case fell apart. So what happens when a federal judge actually defends the Second Amendment more aggressively than the very administration claiming to champion it? It sounds almost unreal, but that's exactly what went down. A United States District Court judge just took a hammer to a long-standing federal gun restriction. For decades, the machine gun ban was seen as a sacred cow, something even hardcore gun rights advocates were hesitant to touch. But a new ruling out of Mississippi is shaking that belief to its core. Back when Donald Trump was running, he promised to be the most pro-Second Amendment president this country had ever seen. But fast forward a few years, and his own Department of Justice was in court arguing that certain firearms weren't protected by the Constitution. That argument came front and center in the case of United States versus Brown, and Judge Carlton Reeves responded with a nearly 50-page opinion that tore that logic limb from limb. In this video, we're going to unpack what this decision really means, how it challenges Trump's Second Amendment reputation, and why this could be the beginning of the end for the so-called untouchable machine gun ban. For nearly 4 full decades, the Hughes Amendment from the year 1986 has been treated like federal gospel. No newly manufactured machine guns for civilian hands. No transferring post-ban units, no wiggle room. But then came the Supreme Court's game-changing Bruin ruling in the year 2022, which redefined how judges evaluate gun laws, putting historical tradition front and center. That shift just sent a seismic jolt through the heart of the machine gun debate. Now gun owners are staring at two conflicting realities. On one hand, Trump rallies are still packed with folks in red hats chanting for gun rights. On the other, his own administration stood behind a machine gun ban that might now fall apart, thanks to a federal judge appointed by Barack Obama. No less, who ruled that there's simply no deep-rooted legal tradition supporting a blanket prohibition on faster-firing firearms. That disconnect raises some uncomfortable questions. Do we settle for political slogans, or are we going to demand a Second Amendment that actually stands up in court based on historical evidence? The phrase dangerous and unusual first popped up in American legal language way back in the early 1800s. But it didn't become the go-to argument for banning guns until the District of Columbia versus Heller decision hit. Since then, lawmakers have leaned on it to justify all kinds of restrictions. Judge Reeves didn't shy away from admitting that a belt-fed rifle is definitely dangerous. But he wasn't buying the idea that it's unusual. The federal government argued these guns are rare, but they're only rare because the law banned them almost 40 years ago. That's circular logic. Banned because rare, and rare because banned. Reeves saw right through that and called it out as a legal dead end. Even shooters, who don't care much about owning a full auto firearm, can recognize the larger threat. That same flawed logic is behind bans on high-capacity magazines, stabilizing braces, and potentially even certain calibers, if the political climate swings that way. If this decision holds up, the whole web of restrictions starts to unravel. Let's talk about Justin Bryce Brown. He wasn't looking to make history. He's just a regular guy from Mississippi with no criminal record, no ties to radicals, and no anti-government manifesto. All he did was purchase an unregistered lower receiver for a Colt M16. That single action turned him into a felon overnight, under federal law. Prosecutors staked their case on Section 922, subsection O of the United States Code, claiming machine guns don't fall under Second Amendment protection. But Brown's legal team fired back using the Bruin standard, arguing there's no historical precedent for this kind of ban, not in the founding era, not anywhere. They also pointed out that machine guns are a lot more common than the government wants to admit. And here's what made Brown's case so powerful. He wasn't some outlier. He could be your buddy at the range, your coworker, or the guy in the next lane running clean groups from a bench rest. For decades, opponents of machine guns leaned on scary images of Tommy gun-toting gangsters or militia types stockpiling arms. But Brown doesn't fit the mold, and that made the prosecution's fear-based narrative fall flat. The mainstream media barely touched the story, but that silence speaks volumes. This wasn't about public safety. It was about paperwork and whether the government can send a man to prison for possessing a single component that changes how a rifle operates. In this case, the court said, that's not good enough under the Constitution. And if other courts follow suit, thousands of Americans previously charged with federal gun crimes might find their records wiped clean. Judge Reeves didn't just make a bold move, he dug deep into legal precedent. He reviewed Hollis versus Lynch, a decision from the Fifth Circuit in 2016 that upheld the machine gun ban. But he pointed out that Bruin changed the playing field, and it looks like the Fifth Circuit might be warming up to that view. Now higher courts have a real dilemma: either uphold Reeves and risk a domino effect of gun law reversals, or overrule him and explain why history and numbers don't matter anymore. Speaking of numbers, Reeves pointed out something the government couldn't refute. According to data from the Bureau of Alcohol, Tobacco, Firearms, and Explosives, around 740,000 registered machine guns are currently in private hands. That's a lot. The feds didn't bother to break that number down between dealer samples and transferable guns. They didn't offer an alternative figure either. Judge Reeves made a clear point. You can't call something unusual when nearly 750,000 exist legally in civilian possession. For context, more than 250,000 muzzleloaders sell every black powder season, and nobody calls those rare. The only reason machine guns are absurdly expensive now is because the market was frozen. Back in the early 1980s, a Colt M16A1 would run you about the same price as today's basic AR-15. But once the Hughes Amendment locked things down, prices exploded, not because of demand, but because of artificial scarcity. Reeves didn't see that as proof of rarity. He saw it as evidence of government interference, distorting the market and denying citizens access to firearms that, by all constitutional logic, should be protected. Judge Reeves didn't stop with the obvious points. He went further and highlighted a lesser-known fact: a quiet but steady rise in civilian exposure to post-ban machine guns through dealer samples. Under current law, any citizen holding a federal firearms license with the Special Occupational Tax stamp can legally possess fully automatic firearms made after 1986, so long as they're being used for demonstration to law enforcement agencies. These guns, numbering well above 500,000, technically aren't transferable to civilians, but they still end up in private hands. You'll see them at public gun ranges, industry expos, and police demos. Regular folks have fired them. They're part of today's gun culture. That reality makes it hard to keep calling them unusual. The same flawed logic bans something, then declare it uncommon, also underpins restrictions on detachable magazines, stabilizing braces, and even threaded barrels. Brown's case dragged that trick into the light. But history delivers the hardest hit to modern gun bans. Back when this country was founded, private citizens owned cannons, swivel-mounted artillery, and even their own warships. Some of those privately held weapons were loaned to the Continental Army in the fight for independence. Not a single law from the 18th or 19th century outright prohibited private ownership of advanced weaponry. In fact, the Militia Act of 1792 required able-bodied citizens to equip themselves with military-grade firearms. As gun technology advanced from the Gatling gun to the Lewis gun to the Maxim, there was still no sweeping federal ban on private ownership. The infamous Thompson submachine gun was perfectly legal to buy, by mail, until the National Firearms Act of 1934. Even then, it was only taxed, not outlawed. The Hughes Amendment in 1986 broke from all that tradition by freezing civilian ownership of new machine guns altogether. And under the Bruin framework, Reeves said that break has no roots in our founding history and cannot survive constitutional scrutiny. The founders made it clear they wanted the civilian population to be armed on par with the military. George Washington asked Congress to support the arms industry. Thomas Jefferson was collecting schematics for multi-shot rifles. James Madison believed America's security came from a population broadly armed. Not a single founding father ever said, "Only if it fires one round per trigger pull." That silence speaks louder than any modern restriction. Now, let's talk about the politics. President Trump's Second Amendment legacy is, frankly, complicated. His speeches still electrify gun show crowds. But let's not forget his administration gave us the bump stock ban, using executive authority to override earlier ATF guidance and declare that a plastic accessory somehow qualified as a machine gun. Some of his supporters excused it as an emotional overreaction to the Las Vegas massacre. But then came the proposed crackdown on pistol braces, finalized under the Biden administration. Yes, but initiated during Trump's term. And now, his Department of Justice is still going to bat for Section 922(0) in court, defending a law that criminalizes mere possession. That's the contradiction. Rhetoric on stage says one thing, but in court, his administration pushed to uphold the same restrictions gun owners have fought for decades. Truth is, federal agencies don't voluntarily give up power, and unless a president directly orders a change in legal strategy, the DOJ stays the course. So, where does that leave us? Do we cheer for slogans, or do we demand action? Judge Reeves's ruling offers a roadmap. He made it clear if someone who openly disagrees with the Supreme Court's constitutional test can still follow it faithfully, then any attorney in the executive branch can too. A future president, Trump or otherwise, could instruct the Department of Justice to stop defending unconstitutional bans. They could immediately recognize that machine guns, suppressors, and short-barreled rifles are indeed arms protected by the Second Amendment. The Constitution doesn't force the executive to defend laws it knows are flawed. That shift in policy could happen tomorrow. Now let's be real. This ruling doesn't blow the entire machine gun ban wide open. It's limited in scope. Right now, it applies only to Brown's individual case. Federal agents still have the authority to enforce the ban. Gun shops still need to log post-sample inventory. But precedent is powerful, and this case just proved that even long-standing laws can collapse when tested against the proper constitutional yardstick. The Department of Justice will almost certainly appeal. The case now heads to the Fifth Circuit Court of Appeals. This is the same circuit that recently struck down laws related to domestic violence, firearm bans, and so-called ghost gun regulations. But don't forget, they also once upheld the machine gun ban in Hollis versus Lynch. So now the court faces a crossroads. Reconcile that past decision with the historical test laid out in Bruin, or double down and risk pushing the issue all the way to the Supreme Court. So here's the real question. If a judge nominated by Barack Obama just made a stronger constitutional defense of your gun rights than Donald Trump's Justice Department ever did, what does that say about where we are? Should select fire rifles be protected under the Second Amendment? Is 740,000 units enough to count as common use? And why are so many self-described allies letting unelected federal bureaucrats define what we're allowed to own? Let me know your take in the comments below. Hit the like button if this gave you something to think about. Share it with your shooting buddies. Subscribe for more no-nonsense coverage of Second Amendment cases. And don't forget to ring that bell so you stay ahead of the next big ruling.